Welcome to EUPrivacyForAll Session32 on GDPR, prior consultation. Articles. In the negotiations regarding Article 34, European Parliament and EU Council adopted a same approach, that is to say, switching from the prior authorization and consultation laid down initially by EU Commission to a prior consultation only. European Parliament suggested to include obligations for processors acting on the controller's behalf. It also suggested that mitigating the risks involved for the data subjects would be necessary, and DPA or data protection officers, considering the consultation is needed because of specific privacy risks that would not be addressed, would be the reason why prior consultation would be made mandatory. EDPB, the new Working Party 29, will also list some processing that would require by default a prior consultation. On its side, EU Council targeted only the controller. It considered that a data protection impact assessment indicating that there is a high risk for the privacy of data subject and the absence of measures to be taken by the controller to mitigate the risk was enough to justify a prior consultation to be kicked off. It also proposed that the DPA would have the obligation to give advice to the controller within 6 weeks following the request for consultation. That would be extendable for 6 additional weeks. Finally, it proposed a list of information that the controller should provide the DPA with. The final draft of Article 34 retains that only the controller has the obligation to consult a DPA prior to the processing whenever a data protection impact assessment would indicate that the processing could result in a high risk for the privacy of data subjects and in absence of measures taken to mitigate those risks. Basically, whenever the controller, according to the DPA, has insufficiently identified or mitigated the risk, the Data Protection Authority has the obligation, within a maximum period of 8 weeks instead of the 6 initially proposed by EU Council, to give advice to the data controller and, where applicable, the processor. This advice should be rendered in writing. This could be extended by 6 weeks. The controller and, where applicable, the processor shall be informed within 1 month of the receipt of the request. The information that should be handed over to the DPA are the following ones: the respective responsibilities of the controller, joint controllers and processors, purposes and means of the processing, measures and safeguards provided to protect the rights and freedoms of data subjects, the contact details of a data protection officer, if any, the data protection impact assessment, and any information that would be required by the supervisory authority. Moreover, Member States shall consult the supervisory authority in the frame of legislative measures to be adopted that would be related to the processing of personal data. Finally, Member States' law might require controllers to consult with and obtain prior authorization from the supervisory authority in the frame of the public interest, and notably social protection and public health. Recital 74 stresses once again the fact that a data protection impact assessment indicating a high risk and the fact that a controller, because of the available technologies and costs of implementation, considering that it cannot mitigate the risk, would make mandatory to consult a supervisory authority prior to the start of processing activities. Doing so would anticipate damage, or interference with the rights and freedoms of the individual. What is striking in this recital is the fact that instead of mentioning the 8 weeks period that a DPA has to render such a consultation, it only mentions a defined period, without prejudice to the fact that a supervisory authority, after such a defined period to render its decision, would still have the right to intervene based on other provisions of the GDPR. Other provisions, such as recital 74A, stress the fact that the processor should assist the controller where necessary and upon request, so this is to be determined, in order to ensure compliance, notably regarding data protection impact assessment and prior consultation. The following recital also mentions that a consultation with the supervisory authority should take place in the course of preparation of legislative or regulatory measures. Article 71H mentions that a data protection officer has the task to act as a contact point for the supervisory authority in the frame of the prior consultation. Finally, Article 53(1)(c) mentions that each supervisory authority shall have the following authorization and advisory powers to advise the controller with regard to prior consultation. Currently, the directive stresses in Article 18 the obligation to notify the supervisory authority and cases in which such an obligation would not apply. In Article 19, the contents of notification, and in 20, where a prior checking is needed. And basically, it is also based, as in GDPR, on the fact that the processing operations are likely to present specific risks to the rights and freedoms of data subject. Finally, Article 21 stresses that publicizing of processing operations is needed. What should accountable data controllers and processors get prepared for? They will have to carry out a DPIA, a Data Protection Impact Assessment, in order to identify privacy risks. In case such a DPIA would demonstrate the existence of high risks for the data subject's rights and freedoms, and the data controller will not be able to mitigate those risks, notably because of available technologies and costs of implementation, it will have to ask for prior consultation of the supervisory authority. On their side, processors will have to help controllers where necessary and upon request, which is still to be determined. Controllers will have to provide the DPA information such as respective responsibilities, purpose and means of the processing, measures and safeguards, contact details of the data protection officer, if any, the data protection impact assessment itself, and any information requested by the DPA. Controllers will also have to anticipate that national legal provisions with regard to the public interest could be adopted. So, for instance, in the frame of social protection or public health. And finally, they will also have to anticipate investigative and sanctioning powers of the DPAs, even if no answer was provided in the frame of a prior consultation. What will be interesting now is knowing more about the EDPB guidance and the common EU approach, and particularly regarding processors, what will mean where necessary and upon request.